Hello and welcome to Spardha Lines, your one-stop destination for the civil services preparation, UPSC, KPSC and other relevant examinations. Today we have picked up a couple of important articles from the Hindu which are very significant from your mains and preliminary examination point of view. Before we understand what this topic is in greater detail, a quick gentle reminder. As you all know, we have been conducting a test series for all those of you who have been preparing for the CTI, PDO and the KAS examinations. We have already conducted 3 tests out of this entire test series, and we also have the 4th test which will be conducted on 17th of December from 10 AM to 11:30 AM. This test will be free of cost. It can be taken up both on the offline as well as on the online pattern, and for the rest of you who haven't taken it up, please do take it so that you understand the real-time examination, how it will be conducted. Let's get started and look into the first article. The first article says on listing of cases in the Supreme Court of India. What is this article speaking about? The article here is speaking about listing of cases. What do I mean by listing of cases? Let's say for example, you have a case at hand. So let's say you are the petitioner in a particular case, you have to file a writ petition. Or let's say for example, you have another appellate jurisdiction case that comes up before the Supreme Court of India. In all these cases, what do? You file a case in the Supreme Court of India and you have some compliance to be done, and ultimately what you will also have is a filing register number, and subsequently the writ numbers will also be given under that case. Once it is done, how is it going to be listed? When I say it is going to be listed, it will come before one of the court halls. It will come before one of the court halls and it will be heard by one of the judges. So the listing of a cases is an administrative work of the Supreme Court of India, whereby once a case is filed, which court will hear it, which judge will hear it, who will hear that particular case is the administrative work. So listing of the cases basically means that once a case is filed, who will hear that particular case and who will hear that case, which judge will hear that case, is what is called as the listing of cases. Now, whenever we speak about listing of cases, how does it work? It happens to be an administrative work. This is where we have the Chief Justice of India who steps into the picture. We have one of the concept called as the Master of the Roster. Who is the Master of the Roster? The Master of the Roster happens to be the Chief Justice of India. So when it comes to the Supreme Court of India, we have the Chief Justice of India who happens to be the Master of the Roster. And when it comes to the state level, we have the Chief Justice of the relevant High Courts who will once again be the Master of the Roster. At the Supreme Court level, it is the Chief Justice of India. At the relevant High Courts, it is the Chief Justice of that relevant High Court who will be the Master of the Roster. What do we mean by the Master of the Roster? Let's say for example, there is a specific judge. Let's say for example, Judge A. This Judge A will hear to all the writ petitions. That is one part. Let's say we have another Judge B. This judge will listen to all the, let's say for example, public interest litigations. Second part. Third, let's say for example, we have Judge C. This judge will listen to all the criminal petitions that come in as an appellate jurisdiction. So who will listen to what cases and how many people will listen to the cases? Is it a single judge? Is it a double judge? Is it a constitutional matter where a minimum of 5 people will listen to it? Who will hear what cases? Ultimately will be concluded by the Master of the Roster, who happens to be the Chief Justice of India. So basically, when we say the Master of the Roster, which judge will hear which subject matter? Is it a criminal petition? Is it a criminal review petition? Or is it a public interest litigation? Or is it a regular first appeal? Or it is a regular second appeal? Or is it to do with the writ jurisdictions? Even in the writ jurisdictions, is it the public interest litigation? What about the contempt matter? Each of these cases, who will listen to what kind of cases, will ultimately be decided by the Master of the Roster, who happens to be the Chief Justice of India in the Supreme Court of India, and it happens to be the Chief Justice when it comes to the state level. So what is this article speaking about? The article here is primarily speaking about two parameters. One is that the author in this case says that whenever it is about listing of the cases, there are few issues and concerns that are persisting in the Supreme Court, says this article. How? Let's say for example, there is one subject matter. This subject matter is being heard by one of the cases. This subject matter is being heard by one of the judges in one of the cases, and this judge is still present in the Supreme Court of India. He is yet not retired. So when we already have the presence of a judge who has already heard the case, why assign this case to a new judge? That's one question. The second question is, when you already have a person who's already heard this case, if it is being given to another case, is it not taking away the bench's power to hear the same case? Is another parameter. Some of the so what this article cases, some of them involving the human rights and functioning of statutory and constitutional institutions, had been suddenly taken away from the benches hearing them and listed before other benches. So there are already benches, which means to say judges who are already listening to the case despite their presence in the Supreme Court of India. This particular case has been heard by some other case. Is it being right? Is this right? That is what is being questioned. So there is clear disregard of the rules, procedure and the established convention, says the author. Added to it, there are a batch of petitions filed by advocates and journalists who were charged under the Unlawful Activities Prevention Act for their work and critical views about the state's response to the Tripura violence of October 2021. These petitions were listed before a bench headed by Justice Chandrachud. Now, as a normal course of action, this should have once again been heard by Justice Chandrachud. However, this should be referred to Chief Justice for appropriate orders on the administrative side, but Justice Trivedi's bench said that the case was listed as per earlier orders and the petitioners were free to take the action. So earlier it was being heard by Justice Chandrachud. Now it is being heard by Justice Trivedi. So the point of introspection is it not violating the basic rule structure and the convention that has been followed? So firstly, the movement of cases already listed and in which notices were issued by a bench to another bench. That's the first perspective. The second is whether a case can follow a puny judge when the senior judge who was heading the court before which the matter was earlier listed was still available. So you already have an existence of a judge who's already heard that case while he is still present in the Supreme Court of India. Why assign this case to a new judge is another question that is being introspected in this article. So the author in this particular case goes on to say that when we look into the Supreme Court rules of 2013, it is silent as to the powers of the master of the roster to constitute roster, benches and for the allocation of the cases. So when it comes to the master of the roster, it happens to be the Chief Justice of India. He has the ultimate administrative power. He would be able to decide to whom and when and how this particular matter has to be assigned. So the master of the roster, who is the Chief Justice of India, will also be supported by the registrar at the administrative level, and once a case is filed, it is fed into the system on the basis of the registry, on the basis of the memo moved for the urgent hearing. That is when this particular case will be listed before that court. However, the Handbook on Practice and Procedure of Court and Office Procedure on the judicial side published by the Supreme Court in 2017 explicitly says that the registry functions on the general and special instructions and orders of the Chief Justice of India as regards to the allocation of work to a bench and assignment of cases from one bench on account of unavailability to another bench. So it clearly points out that it is the Chief Justice of India who has the power to decide what kind of cases will be heard by which judges, and ultimately if there is one judge who is also absent, he is on leave, and it is this master of the roster who will decide which other judge will have to hear this case. So a temporary provision of allocating the cases from one judge to another judge will also be taken up by the Supreme Court of India. Mr. Dev pointed to the section on cases, quorum and listing to note that once a case has been listed or notice issued or dismissed or disposed of or heard in part at admission hearing stage, it can be listed before the bench of the first quorum and none another. So we have senior advocate Dave, who goes on to say that there is one of the cases. If this particular case is taken up for hearing and it is placed before one of the courts, and it is the judge who is hearing the matter. If he is not retired, if he is still present in the Supreme Court of India, it is this judge who has to listen to this particular case when it is posted for the second and the subsequent number of times, despite the roster, because he is aware of that particular concept, because he is aware of the facts of the case, because he has applied his mind already to that case. It is the same judge who has to listen to that case subsequently, and it should not be assigned to a new judge, says Mr. Dev. And at the same time, we have Mr. Bhushan in his turn referred to clause 15 of the overview of the new scheme for automated listing of the cases published in 2017, which noted that subject to the orders of the Chief Justice of India, if the court directs listing or tagging with a matter pending in another court and the matter is listed accordingly, the quorum of the main matter with which the matter is directed list will prevail. So he once again confirms that if a case is already posted and if a respective judge is hearing to that case, then this should not be transferred to another quorum or other judges where they would be rehearing to this entire case. So basically, the article goes on to say that this entire master of the roster and allocation of the cases should be done in a very transparent manner. Reallocating cases without considering judicial propriety is not right, says this article. It is this that we have to understand with respect to this article. Now let's look into the next article. This article says, what is the controversy over Germany's debt break rule? So this article here is speaking about debt break rule. What is this debt break rule? To simplify this entire process, it is nothing but that a government, when it is taking money or procuring money from the market, there is a limit that has been established beyond which it will not be able to take money from the market. This is similar to what we have in the form of fiscal consolidation. This is what we have in the form of fiscal deficit should not be breaching a particular percentage of the GDP. So what is debt break rule? It is a break that has been imposed on the government where they would not be able to supersede their own restrictions import. For example, we have the government of India. I'm just giving you an example of government of India. The government of India, let's say for example, it is coming up with a program or a policy. So it does not have money right now. So what does it do? It immediately issues, let's say, a bond, or it immediately takes money from the market. How much percentage of money can it take from the market? Is it 1% of the GDP? Is it 2% of the GDP? So what is the restriction that is laid? This restriction that is laid in Germany, that is, they would be able to take so and so percentage of the GDP from the market and not beyond that, is what is called as the debt break rule. Why are we discussing about it? That is because Germany's constitutional court ruled unlawful a government move to reallocate 60 billion unused from the sums initially earmarked for the pandemic emergency to a climate and transformation fund. The coalition government led by Chancellor Olaf Scholz was in the breach of the fiscal deficit limit enshrined in 2009 on two accounts. So what does it do? It says that the money that was restricted for the pandemic use, it should be restricted to that particular role or to the infrastructure development and to ensure that the pandemic does not reoccur. So a certain amount of money is allocated for the pandemic. So if this money is being taken out and it is being used for some other purpose, for example, diversion of funds from pandemic related matter to a matter which is to do with the climate change mitigation, can this happen? No, says the court in the Constitutional Court of Germany. So whatever money that is being allocated for the pandemic, it has to be used for the related matters. It can be used for the development of the infrastructure. It can be used for the subsequent events for the prevention of the pandemic. When the money is already invested in the market for the prevention of the disease and the pandemic, why use this money, take away this money and add it into another coffer where you are using for the climate change mitigation? litigation. So the Constitutional Court of the Supreme Court, that is the Constitutional Court in Germany, went on to say that you cannot divert the funds, you cannot make use of the funds where a pre-allocation has already been done by the Constitutional Court with respect to that subject matter. You cannot divert the funds to a new subject matter, says the Supreme Court or the Constitutional Court in Germany. This is where the author also brings into picture the concept of the debt break rule. As I told you, the debt break rule or the balanced budget rule sets a cap on how much governments can borrow to finance various public projects. It restricts the federal government in Berlin from running a fiscal deficit in excess of 0.35% of the GDP, and in effect prohibits the country's 16 regions from any deficit spending whatsoever. The measure was enshrined into law in 2009 by the Grand Coalition government of the centre-right Christian Democratic Union, its sister party, and the budget break is more or less domestic version of the stringent borrowing and spending curbs built into the European Union Stability and Growth Pact. So as I told you, there is a limit as to how much the government would be able to contribute or take from the market, beyond which they would not be able to do, which is about 0.35% of the fiscal deficit in the GDP, which means to say that out of the GDP only 0.35% they would be able to procure or take it from the market, but rest of it they would not be able to do so because of the constitutional and the law validity that has already been put up. So basically this article goes on to speak about Germany's debt break rule and the judgment that has been passed by the Constitutional Court that you would not be able to divert the funds that is already allocated to one of the policies to another policy. And what is debt break rule? You're not supposed to change or procure the money in excess of the already established rules and parameter. So this article basically is speaking about these two parameters, and this can be a point of your preliminary examination where they can ask you debt break rule recently was seen in news is part of which country's rules and regulations. It is part of Germany's policy making. It is this that we have to understand with respect to this article. Now let's look into the next article. This article says, can ChatGPT, the chatbot developed by OpenAI, replace human therapist? What is this article speaking about? We know for the fact that there are a number of AI technology tools. We have the Bard from Google. Recently, Google also came up with what is called as the Gemini. These are the different AI tools that we have in the market, and it all started because of ChatGPT. What are these? These are nothing but the tools that we have where they would be able to assist the human beings. They would be able to assist people in writing the code or in helping and coming up with solutions for a new kind of problems. But mind you, ChatGPT was not able to clear the UPSC examinations, which still goes on to confirm that UPSC examinations are one of the toughest examinations in the country as well as the world, because ChatGPT was not able to clear that on a lighter note. Now what does this ChatGPT or Gemini or Bard do? They basically look into a particular parameter with the inputs that is already fed into the system. The system is able to learn, progress, adapt and immediately change subsequently over a period of time, and ultimately understand whether this entire inputs given is able to give in the right amount of output or the outcome that we are expecting. So at the same time, you want a code to be written. Bard, Gemini, ChatGPT, are they able to give you a precise code? The minute you put it onto the software language, is it able to run the program and execute that particular program? Or you want to fetch an article or you want inputs about a particular piece of work, then is it able to give you a respective outcome for the questions or the inputs that you have given? So what ChatGPT basically does is it collects the information that you require, and it will ensure that there are already pre-existing information in the market, in the ChatGPT, and ultimately concludes that this is the output or the outcome that you are anticipating. This is to do with the general one. What if there is a therapy that is required? For example, you are going through a bleak period. You are not in normal senses. You are going through heart failure. You need someone whom you can speak to. So what do? You go to a psychologist. You put in questions. You say that I'm not able to achieve success in my life. I have broken up with my girlfriend or with my boyfriend. I need that emotional support. So you go put out, you voice out your concern, you cry out, you put out your feelings to another person. Why? Because the other person is better at handling these situations, and he also gives you certain responses which you adopt in your personal life, so that over a period of time you are able to overcome this failure or this emotional trauma that you are going through. So you put out your viewpoint, and other person is also able to reciprocate back because of the experience that they have derived. So what this article basically goes on to say is that you also have voice adaptability that is being built in some of the AI tools. It is able to listen to your voice, it is able to understand what you're trying to communicate, and is also responding in a way similar to that of how human therapists have been able to do. So for example, I say that I have broken up with my girlfriend, I need some emotional support. I'm making a voice to the AI tool. So the AI tool is able to understand my voice. It is also reciprocating back as well. It is saying, yes, I understand that this particular issue persists in so many individuals and humans, and at this particular moment you have to start focusing on your career. You will have another girlfriend in the near future. I'm just making it up. You will have another person who is able to understand your feelings. She is being very considerate, so on and so forth. So it is acting like a therapist. So this article primarily goes on to say, is it able to replace or substitute a human therapist? So ChatGPT has been able to replace, or other AI tools have been able to replace, couple of works in the pipeline for the human beings. Similarly, can it also replace the human therapist? A human therapist will be able to understand the emotional part, the emotional quotient. So is the human therapist also being replaced by the ChatGPT and the OpenAI? The author says it may, but it will not. Why? Because the emotional question is totally different. The ChatGPT or any other OpenAI may be able to reciprocate back, may be able to answer as well, but not beyond a particular point of view, because emotions, and when it comes to these real-time situations, it is only a human who would be able to understand, says this article. So this article primarily focuses on the human therapist. So it says that when it comes to the ChatGPT, so on and so forth, what is the major advantage for the people? Let's say, for example, if I have to book a consultation, or I have to meet one of the psychologists or the human therapist, I have to book an appointment. I also have to wait in a long queue as well. What if I don't get an appointment, or I have had a disastrous day for the entire day, evening or at night I would want to meet a psychologist or a therapist? Will I be able to meet the therapist? No. Why? Because there is also a limitation or a time bar for that individual. I would not be able to meet him at 12 o'clock at night or at 11 p.m. at night. There is a time restriction. But when it comes to ChatGPT or any other OpenAI, they are available 24/7. They would be able to communicate whenever I wish to. Since this is also an advantage where I would be able to communicate at the will and the time that I wish. I need not have to fix an appointment every now and then. I don't have to wait in long queues as well. All that I have to do is give in my inputs, and I will receive answers or suitable emotional reactions from the AI. And ultimately, if I am able to use so, if I am able to implement so, if I am able to adapt so, if I am able to reciprocate to what the ChatGPT is saying, ultimately I may find solace as well. Who knows? So what this article says is, yes, there has been a problem. That problem is the availability and couple of other things. If AI is able to attach and bring new solutions, maybe in the near future, ChatGPT or any of the OpenAIs would be able to answer this as well. This is where the author also brings into picture one of the concept called as the ELISA effect. Remember, this can be very important from your prelims as well as your mains examination point of view. What is this ELISA effect? This happens to be a phenomenon in which people think computer programs or similar systems have become capable of understanding the human emotions or functions because of the way they respond to the user input. It is named after 1960s computer program which also responded to users' albeit with very basic sentences that echoed their original words. So if we are coming to a conclusion that the computer programs and the computer is able to understand the human emotions better than the humans, That is what is called as the ELISA effect. So this ELISA effect is a phenomenon. It is a process, or it is a procedure that people basically believe that computer programs are able to understand the human feelings much better than the human beings, and they have been able to do justice, is what is called as the ELISA effect. Now let's look into the next article. This article is important from your GS paper 2 polity. It is also important from your GS paper 3 security. This is why it also becomes important from the preliminary examination point of view. What are we speaking about? We are speaking about Operation Stormmakers. What is the Stormmakers operation? This happens to be an operation of the Interpol. So basically they did come up with couple of operations, and one such operation to prevent trafficking, or for example preventing fake cryptocurrency investment, fraudulent work from home offers, lottery and online gambling scams. They had to come up with an operation, and that operation is known as Operation Stormmakers. So this happens to be an operation of the Interpol, whereby they ultimately bring an end to some of the issues that have been persisting in the society: human trafficking, passport for forgery, corruption, telecommunication fraud, sexual exploitation, so on and so forth. So while 149 human trafficking victims were rescued, over 360 investigations were opened, several of which are still being pursued by the law enforcement agencies. So basically a human rights office report took up the issue and found that the frauds range from romance investment scams, crypto fraud to illegal gambling. To prevent all this, the Interpol has come together and has created this Operation Stormmakers. Now let's look into the next article. This article here is speaking about a concept called as the person non grata. We have one of the conventions called as the Vienna Convention on Diplomatic Relations. This convention under Article 9 speaks about persona non grata. What is this persona non grata? Let's say for example, we have a diplomat or a person from another country who is in the embassy of this another country. So we have the home country, then we also have another native country. For the sake of simplification, let us assume we have a person from Pakistan who is working in embassy in India. So this person is from Pakistan. He is working in India as a diplomat. So what is persona non grata? If India so decides that this person who is from Pakistan is working in embassy, is acting in a clandestine operations, or is working in a secret operation, or is creating such problems in the country, then India can immediately issue person non grata, which means this individual is not welcome in India, is not acceptable to the country, and as a result is immediately asked to vacate from India and go back to Pakistan. So persona non grata basically means that a person who is from another country living in one of the countries as a form of diplomatic challenge, as a part of diplomatic move, is being asked to go back to his home country, primarily because of the clandestine operations or because of other operations that a person may have conducted in another country. So should reasons be given in this particular case? No, reasons need not be given. Once this person non grata is immediately issued, this person has to immediately vacate and go back to his home country. And at the same time, even if a person has not come to a country, even before that, person non grata can be issued. It is not only for the diplomats, it can also be for the private individuals as well. It can also be issued to the celebrities as well. There have been examples where the Chinese officials have prevented private individuals of United States of America from entering China. There have been celebrities, there have been politicians who voiced out their concerns. Such people have been called in as persona non grata, which means they are not welcome in that country. It is this that we have to understand with respect to this article. So this is it for today. Thank you for watching. All the best.